Hello, everybody, and welcome back to the Callahan Fusco Audio Network. My name is Christopher A. Fusco, and I am your host, as you guys have seen in every single episode so far. Today, with me, I have none other than Christopher DelBove, one of the partners here at Callahan Fusco, and we're going to be talking about third-party litigation funding. Now, Christopher, thank you so much for being here, my man.
Yeah,
good to see you, bro.
Good to see you.
Weather's a little bit terrible today because we have like some of the forest fires going on that are kind of trickling in New Jersey. So if you are in those areas, please stay safe. But the topic today is third-party litigation funding. So Chris, tell me what that is for the people who are listening at home.
Yeah, sure. So at its core, it's basically an arrangement between a financer and a plaintiff or a potential plaintiff whereby they get a loan. So it's really no different than, any loan that you would take on your own. But, I think if you were to ask plaintiff's attorneys, or a plaintiff, they would say it's a loan to kind of float them during a hard period of time, right? Maybe they've been out of work for a couple weeks or a couple months. They're having some problems paying the bills. And, they need to keep things moving before they have money coming in for any potential settlement or lawsuit. But the problem is like most loans, it's usually not a great idea because a lot of times the interest is just so high. And typically what starts out as, a $5,000, $10,000, $15,000 loan turns into a couple $100,000 after 5 or 10 years. And so, for example, I have a couple of cases in New York right now that have probably been going on for 6, 7, 8 years. Sounds like a long amount of time for those of you that are familiar with New York litigation. It's not overly long, right? Cases take a long time.
There's a couple of New York cases we had here that even like when I was younger, we came back for summers and they'd still be going on. Most of them were New York.
Yeah, I mean, we have cases that are 10, 12 years old, not uncommon. And of course, while the case is going on, that whole time, those 10 years, 12 years, the interest is just stacking up and stacking up. And we're going to talk about in a few minutes, but there's a law in New Jersey that actually is seeking to sort of cap some of that interest.
Why does the interest increase?
Yeah, well, it's just simply like an agreement, right? It's okay. It's a private contract,
right?
It's no different than, like a private loan. But unfortunately, a lot of the people giving these loans, are sometimes, not always, of course, but sometimes taking advantage of someone in a tight situation, and it's just kind of how compounding interest works, right?
Got it.
And a lot of times it creates problems in trying to resolve these cases, because someone will say, okay, my injuries are worth X, but I have this loan that I have to pay back $500,000 on. And so, obviously what we see is a case that maybe might only be worth $75,000 is, plaintiff is now arguing is worth over $500,000 because of this type of.
Right. So why does this industry need to be regulated when it comes to this stuff?
Yeah, well, so like I said earlier, for sure, it's definitely a lot of, some of these potential plaintiffs, are being taken advantage of. As I said too, a lot of times the interest rates are really high, 20, 30, sometimes even 40%. It's pretty crazy. And essentially, I mean, it's giving someone a debt that they really have no chance of paying off, and their only chance to pay it off is getting a really good settlement on a case, which isn't always guaranteed. And I'll give you an imagination, right? Like in the way these cases play out is, let's say, like, hey Chris, I think my case is worth, really big number. I think my case is worth $1 million. Okay, great. Why do you think it's worth $1 million? Well, my client has a loan for $500,000. Okay, great. Maybe can I see some paperwork on that? Can I take a look at it? And oftentimes the response is no. Just you'll take my word that there's a $500,000 loan out there. And so that's kind of some of this legislation, which we'll get to in a minute, but that's kind of what some of this is helping to curb is actually seeing laying eyes on the agreements, seeing the agreements. How did you find this funding company? Where is the funding company? Who's it with? Kind of just basic questions like that. Because, guess what? Oftentimes what we're being told a $500,000 payback is, oftentimes it's not, right? Oftentimes it's a lot less, and it's a deal that's cut outside kind of a handshake type deal.
Right. So you said earlier that you said New Jersey. So I'm assuming that there is a new bill in New Jersey, right?
Yeah. So it's very state by state, right? Some states are doing nothing about it. Other states like New Jersey there's proposed legislation. It's not yet been approved. And I don't think it's necessarily really clear if the current governor, Mikey Sherrill, if she would pass this or not, if she would sign this bill if it was put on her desk. And then other courts, for example, like federal courts, there are rules. There are some mandatory disclosures required. So the proposed bill in New Jersey, it requires production of any litigation funding agreements to the court with an ongoing duty to supplement if new information becomes available. It imposes a fiduciary duty on litigation funders to make them jointly liable for costs and sanctions tied to the funded case. So it essentially is making sure that they have a vested interest in the outcome of the case and what does and doesn't happen to the case.
So explain that for me.
Yeah.
As somebody who does not have a law degree, explain that in like simpler terms so like somebody like me can understand.
Yeah, I think at its basic core, it's aiming to give them an interest in the case, because often what's happening now is a lot of times these companies are sort of lurking in the shadows. We don't know necessarily who they are. And if something happens in the case, right, let's say that, you do something in discovery and the judge wants to sanction you or take some other action, this law allows them to be punished as well.
Okay.
So
that's interesting.
So if I think the way it's sort of read is, let's say, for example, the judge is like, produce that agreement between you guys. And sometimes we'll get it, sometimes we won't, right? Just depending on. And I think this law is seeking to perhaps hold that litigation funding company also responsible if it's not produced.
Because I feel like I've heard people in this office, and especially other lawyers, who talk about that this is a problem for like a pretty good amount of time. So the bill in New Jersey explains what you just said, right? Is there anything else about it?
Yeah, so there's a couple more. I think, like key features. It prohibits funders from steering litigation decisions and picking counsel. So again, basically, a lot of times what is happening is these funding companies are sort of like behind the scenes controlling the settlement. Hey, don't take this settlement. Take that settlement. We won't take anything less than X. We won't take anything less than Y. Whatever. So I think this like third prong that we're talking about here is it prevents that. It basically says you can't do that, and they're not in control, because what's happening is a lot of times these litigation companies are lay individuals, right? Okay. They're not lawyers,
right?
So what you have then is you have lay individuals controlling a litigation, or perhaps giving advice to a plaintiff: settle this, don't settle this. Which that's obviously prohibited by the rules of professional conduct.
Got it.
One or two other quick things. It caps funders' recovery at 25%, and without the client's express limit, combined funder and attorney payments no more than 50%. So again, basically, it's preventing the situation I described for you earlier, where let's say the case settles for $75,000, but a litigation funding company gets paid. Is asking for $500,000, right? It's going to make the loan somewhat proportional to ultimate recovery, which I think is probably a good thing. And then the last thing, it sort of gives some teeth, and basically they say that if you don't comply with everything we've listed, if the loan could be unenforceable. Yeah, I guess perhaps maybe that's getting at that maybe the loan wouldn't have to be paid back or something. So that's probably going to lead to lots more litigation.
Yeah, it sounds like this is starting to like kind of streamline this whole process, which would be probably pretty good. But what are the pros and cons to this legislation?
Yeah, so for sure, I think it's a great start, right? I think it's a great start, and probably some sort of minimal disclosure about this stuff is really important and necessary, to the litigation process in discovery, right? Oftentimes, We hear the argument that discovery should be broad and sort of we should be allowed discovery into everything, but not this, right? So hopefully that closes, that kind of bridges the gap a little bit. A con is, I'll speak for myself, right? My own personal opinion, the bill doesn't go far enough, right? It really doesn't curtail the predatory funding practices, and it doesn't really, I think probably defense attorneys should be entitled to all of the information, right? And this bill doesn't necessarily allow for that. I believe the New Jersey State Bar Association also came out and indicated that they felt the bill doesn't go far enough either. I guess we should add that the bill technically would go through the New Jersey Senate, and so there could be like revisions and edits to it, and then it ultimately would go to the governor to sign. So probably if we talk about this in another 6 months, the bill is probably going to look and feel a little different. I would say hopefully it has more teeth, right? It's has more regulations in it, not less. But obviously, Trenton and the politicians are going to probably try to, do it however they see fit.
Right. Yeah, I feel like that's kind of like one thing that with these bills, especially like we talk about like newer topics on this podcast, like we talk about in like the very early stages, which obviously this is already. But hopefully it does go through, but because I do think that this is a pretty good start based on everything you just said.
Yeah, no, and like I said, we'll definitely check back in a couple months. It's probably going to be very different than it is now. But look, it's a good start, and I think a bunch of other states have some have passed similar type rules, and others are working on them, like New Jersey. So hopefully it gets passed, but I guess we'll see.
Yeah. So do you think New York would implement something like this? Do you think it's possible that New York even implements something like this, or any other state if New Jersey does it first?
I certainly would hope so. Obviously, I know Chris Fusco was recently on the podcast and talked about some of the overall sweeping changes that occurred in New York. I would certainly hope that something like this would be considered and passed in New York. But obviously, as we know, these things do take time. And particularly in New York, I know where we have a governor that's sort of running for re-election in the coming cycle. So I wouldn't expect anything before elections this year. Perhaps maybe it might be a nice second term thing for Governor Hochul to look at, but I wouldn't expect anything in the short term.
I've got it. Well, thank you so much for being on the podcast today.
Yes,
everybody. This has been the Callahan Fusco Audio Network. Chris DelBove is our guest today. You can follow him on LinkedIn, which I will put at the bottom of this video. We will see you guys on the next one. Stay safe out there, and we will see you guys later.
Yeah, thank you.